Do judges make laws? If so, what factors contributed to the development of judgment law in the English legal system over time? Allow me, Yap Xin Ning, and other classmates, Tang Kai Ting, Chong Su Wen, Lee Eager, Shafina Binti Ibrahim, Ho Din Yang, and Isabel Sudan Uga Sangko to explain. Let us begin with the concept of separations of powers. It refers to the idea that the primary institutions of state should be functionally independent of one another and that no individual should have powers that cross these offices. The executive, legislature, and judiciary are commonly regarded as the primary institutions. We now turn our attention to the interaction between the legislature and the judiciary under the principle of separation of powers. The legislature makes laws and the judiciary interprets laws. It means that all judges must follow statutes enacted by legislative bodies. However, Ruth Brown Wilkinson stated that, in truth, judges make and change the law. The whole of the common law is judgment. Why wasn't it the same as before as I mentioned? This is because in applying these statutes which are enacted by the legislation, judges must also interpret them, typically transforming the rules from generalistics to specifics, and sometimes filling gaps to cover situations that legislators did not address when the legislation was first drafted. As judges resolve disputes in individual cases, they produce an important byproduct in addition to peaceful resolutions. They develop rules for deciding future cases. Such decisions are referred to as precedents in common law, which is a body of unwritten laws based on legal precedents established by judges. Its precedents have the same authority as a law passed by a legislature. As a result, laws are enacted not only by legislatures, but also by judges, and the law which is enacted by judges has strong influences on the development of the common law.
Hi, my name is Chong Shuwen, and today I'll be talking about the situation where judges make law. Judges usually declare law but not make law. Laws were made by parliament, but in some situations, judges make law as well. Judges make law when there's a lacuna in legislation, which means when there's no law applicable law. In this situation, judges may step in by filling the gap with their judgment. For example, in the case of Factor Ting, there was no law specifying how UK statutes in contradiction with EU law should be handled. Due to the rulings by EU courts, the House of Lords created a new doctrine that allows the legislation to respond to the query without totally abandoning on the idea of legislative supremacy. Judges also make law during situations where cases involve with the consideration of fairness. They are generally expected to treat similarly cases alike by following the principle of stare decisis. But in certain situations, where the application of existing legal precedents in the similar cases may lead to unfair decision. Therefore, judges are required to interpret law by applying fairness and justice. They may create new legal principles or modify the existing ones to address specific circumstances and to ensure an equitable decision. The third situation where judges make law is during interpretation. Parliament is unable to specify every option or clarify every phrase in every legislation. Therefore, the judges are required to interpret the statute such that it can be applied to the case before courts. For example, Bannon criticizes DPP versus Jones in 1999, which concerned a demonstration on the road near Stonehenge. In this case, the Lord looked at the rule that the public have full right to use the highway for purpose like walking, passing, repassing, and else uses related to it, but not demonstrating and picketing. In Jones, the House of Lords stated that the rule leave unrealistic and unwarranted restrictions on everyday activities. And the highway is for public, and public has full right to use the highway for reasonable purposes. Last but not least, judges might make law as well when the laws are outdated. The laws that were made in past might not suit the current situation. It must be improved to stay relevant with the latest situation and technology advancement. The case of Donahue versus Stevenson, where the neighborhood principle was introduced, is an example of the judge-made law. In this case, Mrs. Donahue bought a bottle of ginger beer in a cafe and later found out that there was a decomposed snail in it. Because of this, she suffered injury and proceeded to claim against the manufacturer, which resulted in the creation of modern negligence law and the neighborhood principle. This principle was created by Lord Atkin due to the absence of directly applicable legal precedent and to ensure a just and fair resolution for the case. He created the principle after recognizing the limitation of existing principle and aimed to develop a broader principle that are adaptable to new circumstances. In short, judge-made law for allows for the adaptation and evolution of law to address new issues, correct errors, as well as reflecting societal changes.
Thank you, Shuun, for the insight on how judges make laws. My name is Isabel, and now I'll be adding on to the presentation by talking about what judge-made law actually is. Judge-made law is actually synonymous with the terms case law and common law. Judge-made law, or what many of us know as common law, originated from customs. To give a brief background on common law, it developed organically out of local customs hailing from different regions in England. From the 11th century and onwards, a more consistent body of law developed and was spread throughout the country, thus earning its name common law. Judge-made law rests upon its essential principle of stare decisis, which is the Latin translation of let the decision stand. The principle of stare decisis states that whenever a new problem of law was to be decided on, or if a new ruling was to come about, the decision would effectively and eventually form a binding rule which was to be applied in all future cases that possess similar legal material facts. To further explain or elaborate, judges in lower courts are to be bounded by the rulings and decisions of the higher courts. Hence, judges in lower courts are to follow prior judgments from cases decided earlier on in higher courts. The common law helps to create a more efficient and consistent body of law where the public can sort of gauge and know what to expect of the law. Judicial bodies as well are held to a certain esteem and are required to comply with past rulings, thus effectively creating a more uniform, consistent, and predictable body of law. In a ruling or judgment, there will be multiple statements made by the judge at hand, and it is very important to be able to characterize the binding elements of a case. The binding principle of a case is known as the ratio decidendi. In Latin, it basically means the reason for deciding the case in the way the judge did. All other parts of the case that are said by the judge in the judgment, prior judgment, are known as the obiter dicta, which are the non-binding parts of the judgment of a case. As stated by Joseph Danow in his journal article on the civil law and common law systems, what gives stability and continuity to this system of judge-made law is the doctrine of precedent, which is applied only to the ratio decidendi. However, if a new situation which resembled a prior case but was not exactly the same presented itself, two possibilities were open to the judge. The judge could either apply the rule of the prior case, or he could distinguish the prior decision and limit the application of the prior case in the present case. In extremely dire situations, courts can also overrule cases and provide a new precedent for the point involved. And now there are 3 situations in which cases can lose their binding authority. A case may be expressly overruled by Parliament if Parliament chooses to do so. And alternatively, if a case has not been expressly overruled but is inconsistent with a later act of Parliament, it will be deemed to be impliedly overruled. A case is also reversed if the Court of Appeal agrees with the appeal of a party. Last but not least, courts escape the binding authority when a case is overruled. This is when a higher court dealing with indistinguishable material facts either expressly overrules the earlier case, or on the other hand, produces a ratio which is inconsistent with that from the prior case. All courts are bounded by the Supreme Court in the English legal system, and all other courts except the Supreme Court are bounded by the Court of Appeal. Now, thank you. This is my part of the presentation, and this summarizes the part of our presentation which sort of sheds light on what is essentially judge-made law or the common law.
Hi, my name is Shafina binti Ibrahim, and today I will explain about the factors leading to the development of judge-made law. Commitment to the rule of law can make room for courts to adjudicate under robust precedent following. Thus, the mere fact that an earlier court decided a dispute is a reason for the later court to follow this decision in a relevantly similar dispute. Under the strong version, the existence of a precedent-governed dispute triggers a non-contingent reason for action. The latter court always has a reason to decide the same dispute by following precedent. It is debatable whether the non-contingent justification for adhering to precedent should remain a prerequisite or need to be strengthened. A legal system's commitment to the rule of law can be strengthened by mandating that the same justification be treated as an obligation by the courts. For the time being, a requirement is considered to be an obligation if it results from the combination of a protected reason and an exclusionary reason not to act on certain conflicting grounds. The persuasive mode entails having a bare reason, but the authoritative mode focuses on explaining the idea of having a protected basis to follow precedent. Both kinds of justifications are acceptable for courts in these two traditions to follow precedent. And now, I will explain about the authoritative mode. When a dispute regulated by precedent occurs, the latter court has a protected motive to do so under the authoritative method. When a precedent and a case are legally equivalent, that is, when their similarities matter for legal purposes, and their differences, the latter courts are typically required to follow precedent. A latter court may make a distinction if, on the other hand, these two situations are legally distinct. In other words, subsequent courts have a distinctive requirement under the authoritative mode to either follow or depart from the precedent. The technique by which the latter court demonstrates that the current case involves a novel fact not covered by the precedent and which is legally significant for issuing a different judgment is known as distinguishing. The majority of scholars believe that the differentiating is an essential component of following precedent in common law, which is why the obligation has a distinctive form. The authority is often referred to as the power to overrule when these precedents were established by the same court that may take action for this non-excluded reason. For the legal system, the overruled precedent loses its erga omnes force. As a result, a precedent like this usually stops being a part of the law. Across jurisdictions and even within a single legal system, the grounds on which a judge may reverse differ. To give an example, the House of Lords, now the UK Supreme Court, is permitted under the 1966 Practice Statement 90 to overrule its own precedents where it appears right to do so. Accordingly, not following precedent when it appears right to do so is a non-excluded reason. Next, I will explain about the persuasive mode. When a precedent-governed disagreement emerges, the latter court is required under the persuasive mode to resolve it in accordance with the precedent. As a result, another more significant reason may be important. When a precedent-governed disagreement emerges, the latter court is required under the persuasive mode to resolve it in accordance with the precedent. As a result, another more significant reason may be important. As was previously said, the persuasive mode may stand out for its adaptability because it allows for various degrees of precedent limitation, depending on how much importance is placed on the justification for precedent following. This justification might be highly important if the precedent comes from the tribunal highest court. Even in that case, there might still be choices from different options, depending on whether the previous decision was made by a clear majority, whether its prestigious judge concurred, and so on. However, might be normatively weaker if the precedent was established by a lower court or a court with only one judge. Last but not least, The persuasive mode differs from the null models in two ways. First, in the persuasive mode, subsequent courts always have a cause to follow precedent whenever a relevantly similar case occurs. The null model does not support this non-contingent explanation. Second, courts making decisions in the persuasive mode are strongly supported by principle of judicial transparency and good government to justify the decision to deviate from precedent. This is due to the fact that, all other things being equal, it is against the law to ignore the important precedent without providing justification. Thank you.
Hi, my name is Li Yige. So next I will describe how judges formulate legal principles and what role they play in the development of the Constitution in the context of the social change. When formulating legal principle, judges will consider various factors to ensure that the law formulated are practical and applicable in line with the changes of today's society. Reference comparison, the law enacted due to the different conditions of each region may also be different, and it also provides judges with ideas for formulating legal principles. Judges can refer to how judges in other regions have responded to the same or similar social problems or social changes to formulate legal principle in their own regions. Democrats can also conduct questionnaires to the public, or judges develop relevant websites to allow the public to express their opinions on some social issues. This method can better and deeper enable judges to understand the deeper problems in society through public responses and challenges so that the legal principle formulated by judges can also be more in line with society and more in line with the needs of the public when law allows and the judgment is far and just communication. Judges can also share their opinions on issues through exchanges and discussions with other judges or other departments like legislature. In this case, judges may have different opinions on current social changes, so that it is also possible to formulate legal principles that are more in line with the value of the time. Of course, judges also played a very important role in the development of the Constitution. 1. Judges' judgment makes the Constitution more concurrent. What is mentioned in the Constitution is the protection of the basic rights of the public. By applying the provisions of the Constitution to specific cases in reality, the judges make the provision of the Constitution more concrete, determine the scope of power in the Constitution, and establish legal principle of the deeper understanding and protection of fundamental rights. 2. To supplement the Constitution, changes in society create many new problems. Judges can use the Constitution and their own opinion to explain these issues and formulate legal principles so that the Constitution can be better applied to society. 3. Overturning previous judicial precedents. With the development of the time and changes in social values, some old judicial president cannot solve the new problem that arise. So judges have to right to overturn the old judicial precedent and formulate new legal principles. This allows the Constitution to constantly adapt to change in society.
Hi, I'm Ban Kai Ting. Now we shall move on to the next part and talk about how cases lead to the development of law. Cases are one important source of judgment law. In the English legal system, there have been some significant cases that have led to the legal revolution. So, let's check out the links between these cases and the development of law by referring to their facts, judgment, obiter, and ratio. The first case I would like to introduce is Khalil and Carbolik Smoke Ball Company, which is a landmark case in contract law. In this case, Carbolik Smoke Ball Company advertised a £100 reward for anyone who contracting flu after using their product. Mrs. Khalil buy the product and use it, but she still got the flu. And the company refused to pay for the reward, so she sued the company. The help was the advertisement from a binding contract. Therefore, she can claim her reward. According to judges, the ratio in this case can be put as follows. First, it must be clear and unambiguous for an offer to be enforceable. In this case, the offer made in the advertisement was considered a distinct promise, supported with intention to create legal relation. Second, the offer was an unilateral offer, and it can be made at public at large, including Mrs. Khalil. Last, unilateral offer can be accepted by conduct. In this case, Mrs. Khalil did accept the offer by her action of using the product as directed. She has not been asking for let the company know that she's been using the product. So, it was clear that the ratio in this case explores many principles that must be presented into their modern contract. In the course of the reasoning, Lord Boven also gave an obiter dicta to facts, which were not in issue in this case. He described a situation when someone advertised a lost dog with a reward, the police or relevant individuals are not expected to accept the offer formally in writing. Once they start searching for the dog, and upon they find it, they had already fulfilled the condition to claim for the reward. The obiter dicta, together the ratio, established the principle of unilateral contract, which is an important part of contract law. Therefore, this case is the leading example in the common law of contract, marking how it has shaped the UK's law. It affects the outcome of many cases. For example, the information system Lexis has listed over 200 cases that have cited this case. The next case I would like to discuss is Fitzpatrick and Sterling Housing Association. This case was about whether a gay man can take over the tenancy formerly held by his long-term male partner who had already deceased. The significance of this case is it redefined the meaning of family regarding the Rent Act 1977. In this case, the courts recognized the same-sex relationship can have important family qualities without the need for marriage and blood relationship. When making his decision, Lord Nichols mentioned that there's no national reason to deny the same recognition to a stable and permanent sexual relationship between two men or two women. If a similar relationship between a man and a woman can be accepted. Plus, the key concept in defining the family membership should be the sharing of life together in the same household. Another judge, Lord Clark, stated that the essential bond in recognizing a relationship as family is one of love and affection, which is not casual and temporary, but intended to be permanent. This permanent attachment later leads to other characteristics, such as emotional and financial support, caring for each other in times for need, and sharing mutual interests and activities. The judgment is quite welcomed by gay campaigners. The ratio clearly illustrates that why the definition of family should be expanded, allowing the law to evolve over time. By such, parental privilege extends to a broad category.
Hi, my name is Ho Jin Yang, and I will be adding on a few more cases relating to the development of judge-made law. Firstly, I would like to call onto the case of Donoghue and Stevenson, where Mrs. Donoghue's ginger beer was found to contain a snail and ensued a suit case against the defendant, the manufacturer. The contemporary law of negligence was therefore established due to a personal damage. This marks a development and serves as a basis for all negligence laws made after. Donoghue and Stevenson successfully established the fundamental legal theory underlying the notion of a duty of care, is what gives its greater significance. The neighbor test and its supporting principle was also founded within the process of developing this case by Lord Ekins, which is in use even till today as a base of modern law and order. In addition to that, the case of R&R can also be used. This case had a significant impact on the legislation around rape and consent. The House of Lords ruled that a husband might be charged with raping his wife. Prior to this decision, the common law established a married couple exemption wherein the husband could not be charged with raping his wife. The ruling in this case eliminated the marriage exemption and said that all sexual interaction required permission. And for the third case that I will be adding will be R. Nicholson versus Ministry of Justice 2014. The fact of this case is that the two claimants suffer from irreversible physical disabilities and wanted medical assistance to commit suicide. Through judicial review, they sought declaration that Section 2, Subsection 1 of the Suicide Act 1961, criminalizing the encouragement of assistance of another person, suicide, was incompatible with Article 8 of the ECHR, which establishes the right to respect for private and family life. The legislation governing assisted suicide was being contested. According to the Supreme Court, the prevailing statute which forbade assisted suicide was judged to be compatible with the European Convention on Human Rights. The courts did acknowledge that the Act would need to be revised in the future, owing to evolving situation towards assisted suicide. The ruling demonstrated the possibilities for judicial law growth in reaction to changing social mores. The last case will be R. Miller versus Secretary of State for exiting the European Union. Let's start with the facts. In 2017, following the 2016 Brexit referendum, the UK government announced its intention to trigger Article 50 of the Treaty of European Union to withdraw from the EU. Miller and others sought in the High Court to bring an action for judicial review, claiming that the government did not have the right to give the notice under Article 50 without a vote in Parliament permitting it. The High Court considered that the government did not have the authority to issue the notice under Article 50, but allow appeal to the Supreme Court. In this case, we can understand that the constitutional question of Brexit and the UK government's power to invoke the provision of Article 50 of the Treaty of European Union without legislative consent were at stake. The Supreme Court upheld the legislative sovereignty premise by ruling that an Act of Parliament was necessary to invoke Article 50. This ruling strengthened the position of Parliament in significant constitutional issues and defined the legal procedure for Brexit. From these cases, we can understand the relationship between the cases and the development of law. Generally, the ratio decidendi provides binding and legal principle, while obiter dicta offer persuasive insight. Together, they shape the law's evolution by establishing precedents, promoting consistency, and influencing legislative reform. That's how the case lead to the development of law. Thank you.
So far, we have heard discussions about the situations, concept, factor, and cases of judgment law. Now, I would like to discuss why judgment laws still exist despite the fact that there are some arguments against them. This is because adaptability is one of the advantages of judgment law. The legal system can adapt to changing societal needs and circumstances thanks to judgment law. Furthermore, judges have the freedom to interpret existing laws in light of changing values and principles, ensuring that the law remains relevant and responsive to new challenges. Finally, where legislation is silent or unclear on a particular issue, judges can develop legal principles to fill the gaps and provide guidance in dispute resolution. These advantages enable the law to evolve and remain responsive to society's needs and values, resulting in a more effective, just, and adaptable legal framework. If judges do not make laws and continue to apply the same or rigid decisions to each case, common law will remain stagnant and will not develop. That concludes our presentation. Thank you very much.